All right, so while the president was in the Eastern Cape, news broke that the DA and the Freedom Front Plus would approach the courts to challenge the constitutionality of aspects of the Disaster Management Act. They want to challenge lockdown regulations on things like exercise, e-commerce and the 8 p.m. curfew. Let's take a listen, first of all, to what DA leader John Steenhuisen had to say earlier.
It makes absolutely no sense, for instance, from a health perspective, to push every South African in the country onto the streets for a limited 3-hour period, which by effect of winter is essentially an hour or an hour and a half. Secondly, there's no need to have a military curfew in place. There was no military curfew under the lockdown level 5. And thirdly, there is no rational reason from a health perspective why e-commerce should not be allowed. It is the safest way for consumers to buy products without leaving their homes, without having to stand in crowded shopping centers, without having to exchange money or cards and tap into keypads and interact with products and other goods in the store. It therefore is irrational for government to say, oh, well, it's unfair to other businesses. Well, that's like saying that cell phones were unfair to landlines, or that the motor vehicle was unfair to horse-drawn cars. It is the way the world is moving, and government's draconian clampdown on e-commerce makes absolutely no sense. We're also launching tomorrow another action against the Disaster Management Act and the constitutionality thereof, because there is no provision in the Disaster Management Act for oversight by Parliament of the work that is being done by the NCC. It is simply unconscionable that a NCC can make laws and regulations with absolutely no oversight or input from the legislative arm of South Africa represented by Parliament.
Yeah. All right, so that was the DA leader, John Steenhuisen, earlier speaking about the basis for this court challenge. Let's unpack this more now. Political analyst Ongama Mtinka joins me via Skype from Port Elizabeth. A very good evening to you, Ongama. Great to speak to you as always. I think let me start here just very quickly on this one. I mean, there was a lot of mixed reaction, for example, to the president's address last night to the nation. What did you make of it very quickly before we move on to the other aspects?
Good evening, Griselda, and your viewers. So South Africans were expecting some major decisions yesterday from the president, when in fact he could not deliver some of them because of the processes that still need to be taken in building a consensus with directly affected stakeholders. The reason why he can't repeat that same mistake which was done in the tobacco saga is that once you communicate emerging thinking within government about what to do about those things which South Africans need answers to, you are then trapping yourself to a potential flip-flopping, which when those stakeholders which you should have, whose opinions you should have solicited in the first place, are making their voices heard post facto. So government, while we were disappointed by the fact that there wasn't a clear message as to whether we are dropping the levels, we should appreciate the lessons that government has drawn from the previous tobacco saga about the consequences. And in fact, now even the school is a reopening situation, about the consequences of quickly conveying government decisions when in fact they are still open to being challenged.
Ongama, let's come to what's developing now. So you have the Democratic Alliance and the Freedom Front Plus approaching the courts to challenge the constitutionality of aspects of the Disaster Management Act. Could these parties have a legal leg to stand on, if I may, based on what you and I earlier spoke about as the ambiguity in the Disaster Management Act?
So, Griselda, let me first start by speaking in broad terms about their approach. I find that it is very welcome for different sectors of society to lobby government to hear them with respect to certain things which they may not feel happy about. That's in the spirit of democracy. That shows that we need, to continue to hold government accountable, because in a democracy, political power cannot be exercised in an arbitrary manner. There must always be justifications for state action. Where, for me, this clouded approach of, on one level, challenging government on specific aspects, on another, challenging its very right of doing so. It has a potential for me to cloud issues and actually be confusing to South Africans as to what these parties truly represent. And for me, it signals that this is part of the agenda that wants to push government by force to actually recklessly be on a path that reopens the economy in a reckless manner. And I think that needs to be guarded. But also it does need to be called out as the ultimate objective of the coalition of the Democratic Alliance, AfriForum, and others. But when people apply themselves to the specifics of, for example, this regulation is wrong compared to the other one, that can be understandable. Because
Ongama, just very quickly. Sorry, Ongama.
Sure.
I want to talk about the ambiguity that is within the Disaster Management Act versus what could have been, the state of emergency. With the state of emergency, you would have clearly had certain rights that would be taken away from South Africans as a result of what we are facing, not just as South Africans, but globally. Talk to us a bit about that and where there could be legal standing, in particular as a result of this particular act.
Great. So if you look at the ways in which the country can respond under emergency or disaster situations, there are two approaches that can be taken. One, there's the state of emergency, which is the most extreme. But what's beautiful about it is that both in the Constitution and in the very brief State of Emergency Act, it outlines in very specific terms what roles should be played, what powers are on the president and the executive during a state of emergency. But it spells out very clearly what roles Parliament can take. And also it is sensitive enough to the need for taking decisive and speedy action, while at the same time saying everything is approved subject to parliamentary review. Yeah. So even in the state of emergency, it gives government the ability to implement things quickly, but gives Parliament the ability to actually have a sitting and be able to pronounce on certain things. The Disaster Management Act, on the other hand, is extremely ambiguous on the relations between the two arms of the state, especially the three arms between the executive, Parliament, as well as the courts. So if you looked, for example, initially, what Chief Justice Mogoeng did initially was to correctly interpret what was happening as in fact in line with a State of Emergency Act, which is why I was quite happy when he said, this is how the courts are going to operate. So there was nothing stopping Parliament, as far as I'm concerned, taking the principles from the State of Emergency Act to say, we are dealing with a novel virus, the kind of disasters envisaged in the Disaster Management Act are perhaps do not lend themselves to a complete shutdown of the whole country. But you understand that the state had to do something and do it quickly. So it was nothing stopped Parliament, as far as I'm concerned, to interpret the moment the same way that the Constitutional Court did, and find ways in which it was going to ensure that it keeps the principles as enshrined in both the Constitution and the Act, and proactively find ways to hold the executive accountable.
Ongama, I'm afraid we've run out of time. We've got so much to get through. Thank you very much indeed for speaking to us. I still wanted to do so regarding the spirit of this particular challenge, but unfortunately we've run out of time. I hope to catch up with you again if and when this particular challenge does go to court. Ongama Mtimka, political analyst in Port Elizabeth via Skype.